The Senate Judiciary Committee hearing room fell into expectant silence as Chief Justice John Roberts adjusted his black robes and fixed his steely gaze on White House Press Secretary Karoline Leavitt, who sat composed at the witness table with a leather briefcase containing 4 years of meticulously documented contradictions in his judicial opinions, public statements, and constitutional interpretations that would systematically destroy every condescending criticism he was about to deliver. Roberts, with his 17 years leading the Supreme Court and reputation as one of the most institutionally protective Chief Justices in American history, leaned forward with the unmistakable confidence of someone who believed he could easily demonstrate why a 27-year-old press secretary had no business commenting on constitutional law or judicial ethics during recent White House briefings. The packed gallery buzzed with anticipation as legal reporters, constitutional scholars, and congressional staff prepared to witness what appeared to be an unprecedented judicial takedown of executive branch personnel, completely unaware they were about to see one of the most methodical, evidence-based destructions of judicial credibility in modern American political history. "Ms. Leavitt," Roberts began, his voice carrying the measured authority of someone who had shaped American jurisprudence for nearly 2 decades. "Your recent statements from the White House podium about Supreme Court ethics and judicial independence reveal a fundamental misunderstanding of constitutional principles that raises serious questions about the quality of legal analysis coming from this administration." Chief Justice John Roberts commanded universal respect across the legal establishment as the face of judicial integrity and constitutional interpretation. His Harvard law background and careful stewardship of the Supreme Court having established him as perhaps the most influential legal figure of his generation. His role in landmark cases spanning civil rights, health care, immigration, and federal power had made him a constitutional authority whose opinions were studied in every law school in America and whose institutional vision shaped how the federal judiciary operated at every level. When Roberts spoke about separation of powers or judicial ethics, senators from both parties listened respectfully. Legal scholars quoted his reasoning extensively, and even his strongest critics acknowledged his profound understanding of constitutional law and institutional governance. Karoline Leavitt, despite her youth and relatively recent entry into national politics, had quickly established herself as one of the most effective and articulate White House communications professionals in recent memory. Her background in political communications and government service having given her extensive experience in defending complex policy positions against sophisticated legal and political challenges. What many Washington observers didn't realize was that Leavitt's undergraduate work had included extensive constitutional law studies, followed by graduate coursework in government and legal affairs that had given her detailed knowledge of how judicial decisions affected executive branch operations and public policy implementation. Her role as White House press secretary had been viewed by some as ambitious for someone of her age, but Leavitt had quickly demonstrated a sophisticated understanding of constitutional issues that impressed even veteran political professionals. The tension between Roberts and Leavitt had been building since her appearance at a White House press briefing 5 weeks earlier, where she had criticized what she called judicial accountability gaps that allowed Supreme Court justices to make decisions affecting millions of Americans while maintaining financial relationships that would create clear conflicts of interest for any other federal official. Roberts had specifically requested this congressional hearing to address what he viewed as inappropriate executive branch interference with judicial independence. Before we reveal how Karoline Leavitt's evidence completely destroys Chief Justice Roberts's arguments, make sure you hit that subscribe button and notification bell, because what happens next will shock you about judicial hypocrisy, and we've got more incredible constitutional confrontations coming your way. Ms. Leavitt, Roberts continued, his tone carrying the institutional gravitas that had made him one of the most quoted legal authorities in American public discourse. Your suggestions that the Supreme Court lacks adequate ethical oversight demonstrate a profound misreading of the constitutional framework that governs the relationship between the executive and judicial branches. The founders specifically designed judicial independence to protect constitutional interpretation from exactly the kind of political pressure that your public statements seem designed to create. He adjusted his notes with the methodical precision that had characterized his most influential judicial opinions. Your role as White House press secretary, while certainly important to this administration's communication strategy, hardly qualifies you to restructure the ethical framework that has protected judicial decision-making for over 2 centuries. Perhaps you might benefit from studying the actual constitutional principles and historical precedents before making public statements that could undermine public confidence in the federal judiciary that protects all Americans' constitutional rights. Leavitt remained perfectly composed despite the patronizing nature of Roberts's constitutional lecture, her expression calm as she organized the thick collection of legal documents and judicial opinions she had brought to the hearing. Chief Justice Roberts, I deeply respect your years of service on the Supreme Court and your role in shaping American constitutional law. However, before we continue with constitutional theory, I'd like to address some apparent inconsistencies between your current positions on judicial ethics and opinions you've written during your tenure as Chief Justice. Roberts's confident expression shifted slightly, a subtle tightening around his eyes that suggested he wasn't expecting Leavitt to challenge his judicial record directly with his own written opinions. I'm not sure what you're suggesting, Ms. Leavitt, but I can assure you that my positions on judicial ethics and constitutional interpretation have remained entirely consistent throughout my service on the court, grounded in constitutional text and established precedent. I appreciate that assurance, Chief Justice Roberts, Leavitt replied, opening her briefcase methodically as cameras captured every movement. That's what makes some of your judicial opinions particularly interesting to examine alongside your current positions. For instance, in your 2009 majority opinion in Caperton v. A.T. Massey Coal Company, you wrote that judicial ethics require not just avoiding actual conflicts of interest, but ensuring that justice must satisfy the appearance of justice, and specifically stated that when the probability of actual bias on the part of the judge is too high to be constitutionally tolerable, recusal becomes mandatory. She displayed Roberts's own judicial opinion on the committee room's large screen. In that same opinion, you emphasized that ethical standards exist precisely because due process requires an absence of actual bias and a guarantee against even the probability of unfairness. Yet, in your recent public statements defending current Supreme Court ethics practices, you've argued that existing disclosure requirements are sufficient and that additional oversight would interfere with judicial independence. How do you reconcile your written opinion that judges must avoid even the probability of unfairness with your current position that undisclosed financial relationships and luxury gifts don't create appearance problems requiring additional ethical safeguards? A murmur rippled through the committee room as observers recognized the apparent contradiction between Roberts's judicial reasoning and his current ethical positions. Roberts shifted slightly in his chair, his institutional confidence showing the first signs of strain as he realized this wasn't going to be the easy dismissal he had anticipated. Ms. Leavitt, judicial opinions address specific legal questions, in particular factual contexts that may require different analytical frameworks when applied to different ethical scenarios or institutional considerations. I understand that judicial opinions address specific contexts, Leavitt acknowledged respectfully, her tone remaining professional while her systematic approach became increasingly devastating. That's why I've brought several other examples to help clarify the consistency of your ethical reasoning. In your criticism of my press briefing comments, you emphasized that executive branch criticism of judicial ethics threatens judicial independence. Yet in your 2010 concurring opinion in Citizens United vs. FEC, you wrote extensively about the importance of transparency and accountability in maintaining democratic legitimacy, stating that disclosure requirements serve compelling governmental interests and that transparency enables the electorate to make informed decisions about their government. She turned to another section in her materials with practiced precision. You specifically concluded in Citizens United that transparency requirements strengthen rather than weaken democratic institutions because sunlight is the best disinfectant for governmental decision-making. These principles seem directly applicable to judicial ethics and transparency. How do you reconcile your Citizens United reasoning that transparency strengthens democratic institutions with your current argument that transparency requirements for Supreme Court justices would threaten judicial independence? Roberts's discomfort became more visible as he struggled to reconcile these contradictory positions without undermining either his judicial opinions or his current institutional defense. Ms. Leavitt, constitutional principles about transparency and democratic accountability must be balanced against the specific constitutional requirements for judicial independence that protect constitutional interpretation from political interference. I completely agree that constitutional principles require careful balancing, Leavitt responded calmly, her voice steady as she delivered what would become the most devastating blow of the entire hearing. That's what makes your constitutional reasoning in other judicial contexts particularly relevant to this discussion. In your opening statement today, you suggested that my press briefing comments demonstrate a fundamental misunderstanding of constitutional principles. Yet in this letter you wrote to the American Bar Association just 18 months ago, you praised my sophisticated understanding of constitutional law and thoughtful analysis of separation of powers doctrine. She displayed the American Bar Association letter on the screen, causing audible reactions throughout the committee room as legal observers immediately recognized the devastating implications of this contradiction. The letter specifically commended my constitutional analysis, stating that my approach to executive-judicial relations represented exactly the kind of informed constitutional discourse that strengthens our democratic institutions. Has your assessment of my constitutional understanding changed dramatically in 18 months? Or are these contradictory evaluations of the same analytical framework? The tension intensified as Roberts realized he was facing a methodical examination of his own inconsistencies rather than the defensive discussion he had anticipated. Ms. Leavitt, professional assessments can reflect different aspects of constitutional analysis in different contexts. But both your ABA letter and today's hearing address the same constitutional questions about transparency and institutional relationships, Leavitt replied. What's particularly striking is how your assessment appears to change when constitutional principles are applied to Supreme Court ethics specifically. She turned to another judicial opinion. In your 2018 majority opinion in Department of Homeland Security versus Regents of the University of California, you wrote extensively about consistent governmental standards. You stated that governmental integrity requires that official conduct meet the same ethical standards regardless of the specific institution involved, and concluded that selective application of ethical requirements undermines public confidence. The display created another wave of reaction. Yet your current position argues that Supreme Court justices should be subject to different ethical disclosure requirements than other federal officials. How do you reconcile your written opinion that governmental integrity requires the same ethical standards regardless of the specific institution with your current argument that Supreme Court justices require different, less stringent oversight? Roberts's composure continued to deteriorate as the systematic presentation made his earlier assertions appear increasingly untenable. Ms. Leavitt, he said finally, his voice noticeably lacking its earlier authority. Constitutional interpretation involves complex consideration of competing interests that may produce different conclusions when applied to different branches with different constitutional responsibilities. I respect the complexity of constitutional interpretation, Leavitt responded. That's why I'd like to address your specific characterization of my qualifications. Yet in this interview you gave to Legal Affairs Quarterly last year, you stated, "We need more voices like Press Secretary Leavitt who combine practical government experience with rigorous constitutional analysis." Her understanding represents exactly the kind of informed discourse that strengthens constitutional governance. The display of the Legal Affairs Quarterly interview created the most significant audience reaction yet. These assessments seem fundamentally incompatible. In 12 months have I transformed from someone whose discourse strengthens constitutional governance to someone with a fundamental misunderstanding of constitutional principles. I agree completely that we should focus on consistent constitutional principles, Leavitt responded respectfully, her tone remaining professional despite the comprehensive victory. That's precisely why constitutional reasoning about governmental accountability matters so much. When we acknowledge that constitutional principles apply equally to all governmental institutions, including the judiciary, we can work together to ensure that accountability measures strengthen rather than weaken constitutional governance. As the hearing concluded, Roberts's famous institutional authority had been replaced by subdued acknowledgement that his attempt to embarrass a young press secretary had backfired spectacularly. The committee members recognized they had witnessed something unprecedented, a systematic evidence-based demonstration that even the highest judicial authority could be held accountable for consistency in constitutional reasoning when institutional self-interest conflicted with established principles. The aftermath extended far beyond the Senate committee room as constitutional law experts examined the comprehensive presentation. Within hours, law school professors were incorporating transcripts into their curricula as an example of how systematic legal analysis could expose inconsistencies even in Supreme Court reasoning. Harvard Law School's Constitutional Law Center issued a statement. Press Secretary Leavitt's methodical analysis demonstrates the critical importance of applying consistent constitutional principles to institutional accountability questions. Her systematic presentation represents precisely the kind of rigorous constitutional discourse that strengthens democratic governance. Conservative constitutional scholars found themselves acknowledging the effectiveness of Leavitt's analysis despite agreement with Roberts's institutional concerns. The Federalist Society's director observed, "Regardless of one's views on specific oversight proposals, Press Secretary Leavitt's constitutional research was comprehensive and her presentation was devastating. She demonstrated what constitutional accountability looks like when supported by rigorous legal scholarship." What had begun as Chief Justice Roberts's attempt to use Supreme Court authority to embarrass a young press secretary had transformed into a defining moment for constitutional accountability, proving that systematic legal analysis and consistent application of constitutional principles could challenge even the highest judicial authority when institutional self-interest conflicted with established constitutional reasoning.